And welcome back to the Business News Hour. With us in studio is Sam Kreamer from the Kreamer Law Firm. We're going to be talking about some juicy stuff today. It's about divorce. Well, not necessarily that kind of a divorce. Well, Sam, welcome back to the Business News Hour.
Thank
Nice
you,
to have
Michael. It's
here.
good to be here.
So what are we talking about when we're talking about divorce?
Well, we're not so much talking about divorce specifically as we're really talking about disentanglement.
Disentanglement.
What I'm here to talk about today is what happens when co-owners of a business need to disentangle. What happens when the party's over and that they need to get separated? In effect, they need a business divorce.
You know, lots of people spend lots of time not only formulating these companies, but also working at them.
You will spend more of your working hours in your owner-managed or closely held business than you will anywhere else. It's more time than you spend with your family. It's more time than you spend with your friends. So if you have a co-owner in that business with you, it's very much like family. It's very much like a marriage. So then the question becomes, what happens when problems arise? Problems can arise in several different areas, but one of the biggest areas they arise in is commitment. On previous episodes of your show, I've talked a little bit about how commitment is the one indispensable element of success. And by that I mean, you can't succeed just because you are committed. I mean, it's certain you will fail if you are not committed. The level of commitment that someone has to their business could be the hours they spend, it could be the money they put in, and if you've got two co-owners, sometimes this becomes a asymmetrical type of relationship where one feels they're putting in much more time than the other, or one feels they're putting in much more money, and problems can arise. A second way problems can arise is if the business itself isn't doing well. This could be due to lack of sales, could be due to unintended expenses, it could be due to a number of factors. Rosy optimism, which is what people have when they form a business.
Oh, sure. Everybody's, this is going to be wonderful. And I've known you forever.
Known you forever, and we're best friends forever, and this is what we've always wanted to do. But by the same token, it turns out that reality can sometimes be different. John Lennon taught us that life's what happens while you're making other plans.
So when we're formulating this business, is it wise then, Sam, to have some kind of an exit strategy? I mean, that sounds like throwing water on the party, so to speak. But what do we do?
Essentially, the two options are either you plan for a disentanglement or a disentanglement happens. Now, a disentanglement could happen virtually by someone dying who is a co-owner of the business. That's a form of disentanglement. But then you've got the problem, what happens with their estate? What happens with the heirs? What happens when someone who is significantly less experienced than the surviving co-owner wants to come in and tell the co-owner how to run the business? These are problems. Well, what can be done about these problems? Really, there's two aspects of the solution to the problem. One aspect is a statutory or legal solution, and the second aspect is arguably a negotiated disentanglement.
And I would suspect that the judicial decision is far more expensive than the other.
It's more expensive, and there's an old adage that divorce never forms money. Accordingly, the real problem with using the statute is that it's sort of a sledgehammer approach to a fly problem. Not that disentangling is a fly problem, but the point is it's so much stronger. The statute basically provides that a company can be dissolved in the event the co-owners simply cannot continue to coexist. Now, it's got to be a little bit more than just disliking each other. It's got to be something that causes something of a paralysis in the business, that the business can no longer really function efficiently. It has to be something where one owner can fairly effectively point to inappropriate acts on behalf of the other co-owner. It's got to be something that really causes the business to be at a standstill. It's not just, I think we really should fire Joe.
So it's got to show some harm, is that it?
there has to be some definitive harm. The statute, again, I suggested that it's a sledgehammer to a fly situation. I refer to as the Samson option. And many of our listeners realize that, Samson pushed the walls of the temple out, the temple fell down and killed everyone within. And that's a little bit like what the statute is, because the statutory remedy is to dissolve the company.
Ouch.
And the dissolution of a company can be ugly on so many levels. One level it could be ugly on is it could lead to a fire sale of assets. I mean, that's obviously a time when the vultures come in to pick the bones. Another way it could be ugly is there could be some non-divisible assets, a name of a company, a phone number, a location, which really the parties can't distribute amongst them. One of them has to wind up with it rather than both. Accordingly, a dissolution can be a really tough, ugly thing, and quite honestly, it's a bit of a black mark against the credit of both parties.
Well, because this is all happening very publicly. Too.
It's happening publicly and it's happening economically. Most of the time when these problems occur, there is some outstanding debt. Dissolving a company does not dissolve the debt. And just because you may no longer be a co-owner of the business does not mean you're not a co-borrower on the business's indebtedness. Another issue can be that the two co-owners simply can't work together anymore. And one decides, I've just got to fire that other person. They're just awful in so many ways. Well, you can fire them possibly, but that doesn't mean you get to take away their stock. And accordingly, you could wind up with a very angry former employee who is also still a co-owner.